A right infringed the case of Justin Bryce Brown. The Second Amendment of the United States Constitution stands as a bulwark against tyranny, guaranteeing the right of the people to keep and bear arms. Yet this fundamental right is under constant assault. A recent federal district court ruling in the case of Justin Bryce Brown versus the United States exemplifies this alarming trend. Mr. Brown, a law-abiding citizen, found himself ensnared in the web of unconstitutional firearm regulations. His alleged crime? Simple possession of a machine gun. The government, in its relentless pursuit of disarming the citizenry, sought to punish Mr. Brown for exercising a right explicitly protected by the Second Amendment. This is not the first time a court has ruled this way. Last year, another federal court also ruled that machine gun bans were unconstitutional. It highlights the urgent need to reaffirm the original intent of the Second Amendment and to resist the relentless erosion of our fundamental rights. The fight for liberty is a perpetual struggle, and we must remain vigilant in the face of government overreach. Dangerous and unusual. A flawed argument. The government's attempts to justify its infringement on the Second Amendment often hinge on the flawed argument that certain weapons are dangerous and unusual. This argument, however, crumbles under the weight of scrutiny. The very purpose of the Second Amendment is to ensure the citizenry has access to arms, including those that may be deemed dangerous by those in power. The Founding Fathers understood that the right to bear arms served as a deterrent against tyranny, both foreign and domestic. To limit this right to ineffective or obsolete weapons would render the Second Amendment meaningless. A fight against a tyrannical government will not be fought with pillows and flower petals. It would be akin to saying that the First Amendment protects only those forms of speech deemed acceptable by the government. The danger lies not in the arms themselves, but in the hands that wield them. A free society trusts its citizens to be responsible for their actions, rather than stripping them of their rights based on the actions of a few. Common use, a cornerstone of the Second Amendment. The government's attempts to restrict certain types of firearms often rely on the notion that they are not in common use. This argument, however, ignores the historical context and the evolving nature of firearms technology. The Second Amendment was not meant to be a static document, frozen in time. The Founding Fathers could not have envisioned the specific types of firearms that would exist centuries later. However, they understood that the right to bear arms encompassed any and all arms that would be necessary for a well-armed citizenry to defend against tyranny. To suggest that the Second Amendment only protects muskets and flintlock pistols is to ignore the clear intent of the framers. The right to bear arms must evolve alongside technology to ensure that the citizenry remains capable of defending itself against all threats, both foreign and domestic. The Founders' Vision, an armed citizenry, a free state. To truly grasp the scope of the Second Amendment, one must delve into the minds of its framers. The Founding Fathers, steeped in the writings of Enlightenment thinkers like John Locke, recognized the inherent right of individuals to defend themselves, their families, and their property. They had witnessed firsthand the dangers of a tyrannical government, and were determined to prevent such tyranny from taking root in the newly formed United States. The Second Amendment, therefore, was not merely about hunting or self-defense against criminals, it was about ensuring the citizenry had the means to resist government overreach. It was about preserving liberty for generations to come. The Founding Fathers understood that a well-armed citizenry served as a powerful deterrent against tyranny. They believed that a government that feared its people was more likely to respect their rights. Section 5. The Constitution's clarity, no room for arbitrary restrictions. The language of the Second Amendment is clear and unambiguous. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. These words leave no room for interpretation or for arbitrary restrictions imposed by those in power. The right to keep and bear arms is not a privilege granted by the government. It is an inherent right, endowed by our Creator and enshrined in the Constitution. Any attempt to restrict this right, whether through bans on certain types of firearms or through burdensome regulations, is a direct assault on the very foundations of our republic. The Second Amendment, like all other rights enshrined in the Bill of Rights, is absolute. The Constitution clearly lists the powers of the government and what type of things they can regulate. Nowhere in Article 1, Section 8 is the power to regulate firearms. Section 6. Echoing the Founders' Voices of Liberty. The Founding Fathers' unwavering belief in the right to bear arms is echoed in their writings and speeches. Thomas Jefferson, the author of the Declaration of Independence, wrote, "No free man shall ever be debarred the use of arms." This sentiment reflects the Founders' deep-seated conviction that a well-armed citizenry is essential to a free society. Patrick Henry, a fiery orator of the American Revolution, famously declared, "Give me liberty or give me death." These words encapsulate the spirit of the Second Amendment, the unwavering resolve to defend liberty even at the cost of one's life. These are not merely words uttered by men long gone, they are the timeless principles upon which our nation was founded. To disregard them is to betray the legacy of liberty bequeathed to us by those who sacrificed so much to secure it. Section 7. A legacy betrayed, the erosion of a fundamental right. Despite the clarity of the Second Amendment and the Founding Fathers' intent, this fundamental right has been slowly eroded over the years. Politicians, driven by fear-mongering and a desire to retain control, have chipped away at the Second Amendment through a series of incremental restrictions. Each new law, each new regulation may seem insignificant on its own. However, taken together, they represent a steady creep towards disarmament. This slow erosion of our rights is often insidious, barely noticeable until it is too late. We must resist the urge to compromise on our fundamental rights. History teaches us that governments are rarely satisfied with limited power. Once they have encroached upon one right, they will inevitably seek to encroach upon others. Section 8. Reclaiming Our Birthright. The Fight for the Second Amendment. The fight to preserve the Second Amendment is not about guns, it is about liberty. It is about ensuring that the citizens of the United States retain the means to defend themselves against tyranny, whether it comes from a foreign power or from our own government. This fight requires unwavering vigilance. We must hold our elected officials accountable for upholding the Constitution. We must challenge unconstitutional laws in court, and we must never cease to educate our fellow citizens about the importance of the Second Amendment. The Second Amendment is not a relic of the past. It is a living, breathing document that remains as relevant today as it was when it was written. It is the cornerstone of our liberty, and we must defend it with unwavering resolve. The Second Amendment is very clear. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Did you get that? Shall not be infringed. That means no restrictions, no regulations, no permits or permission slips, no limits on type or caliber, no limits on rate of fire or magazine capacity, no limits on who can carry or own, no regulation on where, what, or how you can carry. Shall not be infringed means exactly that. We are finally seeing a move in the right direction. With pro-Second Amendment laws being introduced in the Senate and House in recent court rulings, we might soon see a return to the true intent of the Second Amendment. If it's not in the Constitution, then the government has no power to do it. Nowhere in Article 1, Section 8 is the power to regulate firearms. Any and all gun control regulations or restrictions are unconstitutional. We have a duty as citizens to resist any unconstitutional law. Police officers also have a duty to resist any order to enforce an unconstitutional law. The time is now to stand up and make your voice heard. As American citizens, we must no longer stand by and let a corrupt government infringe on any of our rights. I will not respect or follow any unconstitutional law that infringes on my rights. Stay frosty, my friends. Keep your head down and your powder dry.